19 times. We're going to cover a range of estate planning topics this morning, where we hope our practical experience at Edwin Coe will be of interest to you and, where relevant, your clients. Let me remind you briefly who Edwin Coe are. We're obviously talking about private client subjects this morning, so this introduction is with a private client bent. We are ranked as a top private client law firm by ePrivate Client and the Times Best Law Firms. We're ranked in the independent legal directories, including Chambers and Legal 500. Normally, we're based in Lincoln's Inn in London, but currently, like many of you, I'm sure, we are working from home from various parts of the country. We have over 170 people currently, mostly working from home. Let me just tell you who our speakers are today. That includes me, Alison Broadberry, partner and head of private client at Edwin Coe, my colleague Matt, partner in private client. We will be speaking through the presentation, and we also have on the line our colleague, Senior Associate Wendy Hall, who has the most important role. She will be monitoring the questions as they hopefully come through on the question facility on this tool, and she will start with the questions when we get to the end. Now, at the moment, we're rather deliberately hiding ourselves, so you don't have to suffer looking up at us as well as the slides. But once the presentation is over, we will reveal ourselves so you can see us as well. Turning to the agenda for this morning. So our presentation and talking through the slides should be around 40 minutes, leaving up to 20 minutes for any questions that you have at the end. And as I said earlier, if you have questions, please do type them in as we go along. If you can't work out how, or there's a problem, or we don't get to your question at the end, please do feel free to contact us individually after the presentation. So for the agenda, I will carry on for a little bit, and I will recap on some recent changes from the budget and the new tax year 2020. I will then cover some essential estate planning and issues relating to executing documents in the current times, before passing over to Matt, who will remind you of some recent changes to the Intestacy Rules, and he will also talk about testamentary freedom, how best to avoid claims against clients' estates, and some top tips for securing the transferable nil rate band and residence nil rate band. I will then end with some practical information on surplus income gifting, and then we will answer any questions that you have had. So turning now to an update, recap on some relevant changes in estate planning that arose from the budget and the new tax year 2020. Probably some time ago now, but it was quite recent. I'll just ask anyone who's not talking to mute themselves at the moment, please. For inheritance tax, the residence nil rate band increased to £175,000. Matt will come on to that later. For capital gains tax, the annual exemption is now £12,300. And as I'm sure you'll know, entrepreneurs relief was renamed a very catchy heading of business asset disposal relief, or BAD, and the lifetime limit changed from budget day to reduced from 10 million to £1 million. For property owners, those of you or your clients with property owners, there were quite significant tax changes, and now there are only 30 days from a disposal to report and pay any CGT liability. The principal private residence exemption, that final period of exemption, is now halved to 9 months, other than if the disposer is disabled or in a care home. Lettings relief has been abolished, other than for the very few live-in landlords. And corporation tax is remaining at 19%, not going down to the previously stated 17%. I mentioned corporation tax in the context of estate planning because, as many of you will know, in recent years, due to the differential tax rates, family investment companies, so-called, have become increasingly popular due to the lower rates. Now, unfortunately, many advisors of various sorts have slightly productized family investment companies, and that is partly why HMRC established last year their family investment company team to review any tax risks associated with creating family investment companies, with a particular focus on inheritance tax implications. So it's really important to remember in estate planning that all solutions are bespoke to the client. They aren't products, and there's no one size fits all. So let's look at estate planning, particularly in the current difficult situation. So one impact, as many of you will know personally and professionally, is generally that asset values, some asset values, are lower. This may present an opportunity for some clients to gift or restructure assets where there is no or now a lower CGT cost. For example, gifting property to children. We are certainly seeing a number of inquiries of this nature where clients are wondering if now is a good time to make that gift that they had been thinking about, but not previously because of the CGT. And these things are always important, but it's even more important than usual for clients, and if you are an advisor to a client, for you, to check that if clients have life policies, they are in an appropriate trust with appropriate trustees. Any pension policies have got up-to-date and appropriate nominations or letters of wishes or pilot trusts as appropriate in place, and that all clients have got effective, valid, lasting powers of attorney, or increasingly at the moment, general powers of attorney are being put in place to assist with specific transactions or a specific time period. And it's even more important for all clients to ensure that they have got the best and the most appropriate wills and letters of wishes in place for their circumstances and objectives. We've certainly seen an increase in inquiries about and instructions for putting wills or updating wills in place. And although we are all working from home, we're very able to advise clients, take instructions, and get documents out to clients in the post if needs be. But what about executing documents currently? Now, with the current lockdown situation and social distancing, it can be very challenging to execute documents. And of course, it's really important to ensure that if you or a client is executing a document, that it is valid and has the effect intended. So what does that mean? How do we execute documents? Well, the first point is that it depends what kind of document it is. This only covers England and Wales, of course. There are other rules in different jurisdictions. For wills, there are very strict formalities which must be observed. The Wills Act 1837 requires wills to be signed by the testator in the physical and actual presence of two witnesses who must also sign still in the testator's presence. So these signatures cannot be electronic, they must be actually hand written, and the witnesses cannot oblige through a video call or FaceTime. They must be actually physically present. So in current times with lockdown and social distancing, very typically our clients are using perhaps next door neighbours and doing their best to keep 2 meters apart. And when the weather is nice, we've certainly had instances of documents being put on a table with hand sanitizer and different pens so that each party can move to and fro the table and affect the relevant signing, but they're all in each other's presence and they see each other sign. Or on a windowsill. That's happened as well. There are also reports of meeting in car parks to sign on the window bonnet. That'll work too. Now, you may know that the Law Society has been in touch with the Ministry of Justice in order to try and relax these rules, but so far they have not been relaxed in England and Wales, and it seems unlikely now that they will be, even though they have been in, for example, New Zealand and Jersey. What about deeds? A deed must also be signed, this time in the presence of only one witness, but like wills, the witnesser must also be physically present. Now, unlike wills, all of these signatures could in theory be electronic, but the person signing and the witness must all be together at the same time. For certain deeds, a client could appoint an attorney to sign on their behalf, but that is not generally going to be suitable for documents we need often in estate planning, such as declarations of trust or deeds of gift. For contracts, electronic signature is fine, has been used for some time and even more so now. The law for executing documents is in all sorts of different places, but if you want some fun weekend reading at any point, may I refer you to the Law Commission report noted there in September 2019. Sadly, its title seems to have disappeared off the slide, apologies, but it's called Electronic Execution of Documents, which recommends there is a review and potential relaxing, but we're not there yet. So now I'll pass over to Matt to carry on and update you on the recent changes to the Intestacy Rules.
Good morning, everyone. So firstly, may I just start by saying that any references I make to spouses throughout my talk also includes civil partners. The Intestacy Rules are a set of statutory laws that govern an individual succession where there is no will in place. As an initial point, it's worth noting that any jointly owned assets held as joint tenants will pass automatically to the surviving co-owner. However, the remainder of the deceased estate, including the share of any property held jointly as tenants in common, will then be distributed in accordance with these rules. The rules on intestacy were updated in 2014, where the Inheritance and Trustees Powers Act 2014 brought in 2 key changes and a government commitment. Firstly, in situations where there was a surviving spouse but no children, the estate was previously shared between the spouse and the parents, or failing that, the deceased siblings, which had always seemed very strange. Thankfully, this was updated to provide that the whole estate in those circumstances now passes to the surviving spouse. The second change was where there's a surviving spouse and children, whereas before the surviving spouse stood to receive the fixed net sum, often referred to as the statutory legacy, outright, and then half the remainder on a life interest trust. Now that remainder half share is also outright rather than on trust. And lastly, as part of the reforms, the government also committed itself to increasing the amount of the statutory legacy in line with CPI every 5 years. In accordance with this, with effect from 6th February this year, the statutory legacy was increased from £250,000 to £270,000. So why do we still advise clients to prepare wills? Well, firstly, there's no such thing at law as a common law spouse. They don't exist as a legal entity and certainly don't have any legal protections or rights. As such, unmarried cohabitees do not receive anything from a deceased estate under the Intestacy Rules. Therefore, if a person wishes to provide for a cohabitee, they can still only do so by making appropriate provision in a will. Secondly, a hugely common misconception and often an incorrect justification for not having a will is the view that a spouse will automatically inherit everything. As you know, where a deceased dies leaving children, the estate is shared between the spouse and those children. This can be particularly problematic and could lead to important assets, such as the family home or significant investments, being divided or co-owned by the surviving spouse and the children. Next, that share that any children inherit from a deceased parent's intestate estate is outright provision at 18. For many people, the idea of their children inheriting any amount of money outright at 18 would be too much too soon, and therefore for those clients it's essential that they have a will in place to provide mechanisms to protect or delay a child's inheritance beyond 18. Although in general no IHT is payable on assets passing to a surviving spouse due to the availability of the spouse exemption, it would, however, be chargeable on any share inherited by the children. This liability would no doubt come as an unwelcome shock to most families where there was an expectation that the surviving spouse would inherit the entire estate inheritance tax-free. Even if the children's share is under the nil rate band, it would still use up a portion of the nil rate band that would have been transferred to the surviving spouse and available to the surviving spouse's estate on their later death. We do still have the ability in the UK to reorganise a deceased estate within 2 years of death by way of post-death variations, even in cases of intestacy. However, they're extremely difficult to do in cases where a minor child stands to inherit a share of the estate, as a court application would be required to approve any variation. Now, I'm sure most of you will be aware that under English law, we have the concept of testamentary freedom. Most civil law countries ensure that certain fixed provision is made to various classes of family member, irrespective of the testator's wishes. It's therefore a key hallmark of succession law in England and Wales that you are free, in theory, to leave your estate to whomever you like. I say in theory because testamentary freedom in England and Wales is actually tempered somewhat by statute. The Inheritance Provision for Family Independence Act 1975 affords statutory protection to certain classes of person who are permitted to bring a claim through the courts to challenge the provision or lack of provision that they've received under the terms of a will or the Intestacy Rules. The classes of protected person are spouses and civil partners and former spouses or civil partners, children, cohabitees, but only where the couple have been living together for more than 2 years as husband and wife immediately prior to the death, and other people who are financially dependent on the deceased. Individuals falling into one of these classes have the right to make a claim against the deceased estate for reasonable provision. The definition of reasonable provision in the Act differs depending upon the class of the claimant. For spouses, the provision is such reasonable provision as would be reasonable in all the circumstances of the case, whereas for all other classes of potential claimant, the definition is limited to provision reasonable for his or her maintenance, i.e. income provision only. So, In 2019, a Direct Line research survey found that 1 in 4 people nationally would challenge provision in the will of a loved one if they are unhappy with that provision, with a regional figure for London nearing 1 in 3, standing at 29%. So how do we approach the situation and advise in circumstances where a client is telling us they wish to disinherit someone whom we have reason to believe could bring a claim after the testator's death? This is where the importance of our approach to drafting wills comes into its own, and where we can add real value to clients. Firstly, the client should be warned of the potential risk of a challenge to the will after their death, and that ultimately their wishes might not be fulfilled. Unfortunately, there's no magic wand or definite way of protecting an estate against a claim. As long as an individual falls within one of those protected classes, they have legal standing to at least commence an action, regardless of the strength of their claim. Clients should also be made aware of this. However, having said that, there are a number of practical steps that can be taken to reduce the potential for or impact of any claims. Probably the most obvious step is for the testator to deal with any issues during his or her lifetime. If they're considering treating their children differently as opposed to an equal division of the estate, it's far better that the children know this is going to happen and have heard the reasons behind their parents' decision from that parent. This is preferable to it coming as a surprise following the death of the parent, where grief, surprise, and a potential feeling of being unloved are all thrown into the mix. It would be much more likely to end in a claim. This is obviously not always practical in circumstances where there's been a complete breakdown in the relationship. Another sensible approach is to consider making a degree of provision in the will, as opposed to disinheriting the individual completely. As claims are linked to reasonable provision, the testator could consider what provision could be made in the will to meet the bare minimum requirement to at least make any disappointed beneficiary think twice before commencing an action. The client could also consider having a will whereby they leave their estate to trustees on flexible trusts, and for those trustees to make decisions at the time of death according to any letter of wishes and the particular circumstances at the time, in an attempt to avert any potential conflict. A testator should also consider leaving a letter with his will explaining the reasoning and background behind the terms of that will. As claims can only be made after the testator has died, such a letter is generally the only way the courts can hear from that testator. Claims are brought against the estate of the deceased, but are effectively argued between the beneficiaries. The executors are impartial bystanders waiting for the court's determination of how the estate should be distributed. However, it is always useful for executors to have information and documentation to present to the court regarding the testator's thought process and feelings at the time of preparing the will. Care should, however, be taken in the preparation of these letters. Vitriolic letters and views have been criticised by the judiciary and have generally not been well received, even though its purpose may just have been to explain the testator's reasoning. Our opinion is that any letter would much more likely be considered sympathetically and, more importantly, taken seriously and carry some weight if it were drafted in more positive terms. For example, the letter could include the reasons why the testator has chosen to benefit some family members more than others, rather than focusing on why less. Some children may have done very well for themselves, whilst others may be struggling financially. A testator can be immensely proud of those doing well, but feel a greater moral need to help others more. The wish to vary provision, as between family members, may not be to punish any person, but rather because the testator believes they have a greater personal responsibility for their money to go to support a more needy relative. The letter could also explain that the testator reasonably considers that he or she has already made sufficient financial provision during their lifetime. This should ideally include dates and amounts of any provision made. Now, this will assist to dispel any assumption the courts could raise that financial dependents have an expectation to continue to receive provision after death. In circumstances where the intention is for large provision to go to charity rather than to family members, the letter could contain a clear explanation as to why the testator wishes to leave a share of their estate to charity, and/or why they have chosen or have a particular association with the charity or charities, or at least type of charity. Even if the testator hasn't been a financial supporter of those charities during their lifetime, it is worth recording in writing the testator's rationale so that the courts don't just form the view that he or she would have given it to anyone but their son, for example. It could be that the testator wasn't financially able to fund charities during their life, but that they always wanted to make provision to that charity or charities on their death. Where the reasons behind the decisions are as a result of relationship breakdown, so that it hasn't been possible for the testator to deal with it during their life, we don't think it necessarily hurts to record this factually, but we don't think there is any real benefit in apportioning blame. At the end of the day, it's just one party's view, and in court, it doesn't seem to come across very well. Remember, there are always two sides to every argument, however hurt the testator may feel. It's therefore much better to set out the relationship breakdown by presenting it as a factual timeline. I haven't heard from or been in contact with my son for X number of years or since X year when whatever incident occurred. As such, I don't reasonably think that he would have any expectation to receive anything from my estate, and it will no doubt come as no surprise to him that I have left the bulk of my estate too, is common wording. This could then be reinforced with the positive reasons behind the provision that has been made, as I've just mentioned previously, for example, to X charity with the reasons behind that charity, or to my daughter, who has maintained an excellent loving relationship with me, is in very frequent contact, and has taken such steps as have been necessary to look after me for the last X number of years since their mother died. Lastly, life insurance could be considered. Now, this could have a variety of uses. For example, it could be used to compensate the preferred beneficiaries privately and separately away from the will, which then makes it the provision regardless of how the estate is eventually shared or depleted by any claims. It could be used to provide a war fund to enable any claims to be rigorously defended, or it could be used to allow decisions over the distribution of the policy proceeds in an attempt to avert any potential claims away from the will and the courts. So moving on to the transferable nil rate band and residence nil rate band. In recent years, HMRC have investigated or inquired into approximately 25% of all estates where IHT was actually payable. HMRC have clearly woken up to the additional tax that could be raised from investigating IHT accounts, and we're of the view that this figure is only going to rise further. As such, for the final part of the talk, we wanted to provide some practical tips on a few areas where, from our experience, HMRC have started taking more interest in what is initially reported. Most of this revolves around good record keeping, putting executors in the best possible position to make whatever claims for reliefs or exemptions that the estate is entitled to successfully. Also, IHT is payable 6 months from the end of the month in which the death occurs, so there isn't a huge amount of time for the executors to search for and collate all the information and documentation that's required to claim reliefs and exemptions and properly calculate the IHT liability where it isn't readily available. So firstly, I want to mention the transferable nil rate band, which has now been around for nearly 13 years. Although relatively uncontroversial, I have set out on the slide the documentation and/or information regarding the estate of the first deceased that is needed to complete the appropriate IHT form. I'm not going to go through each of them here. However, it's easy to see that when there's been a considerable time that has elapsed since the first death, and particularly in cases where the surviving spouse either didn't take any advice or didn't obtain probate, this can prove very problematic for the executors on the second death to obtain. So as such, we recommend that in cases where wills or estate planning advice is being provided to a surviving spouse, these issues are discussed and steps are taken to collate all the documentation at that time so that they can be placed on file or stored with the will and other pertinent documents. As mentioned by Alison earlier, the residence nil rate band is now £175,000. With a transferable residence nil rate band, that's £350,000, meaning an IHT saving of some £140,000. Also, when taken with a nil rate band and transferable nil rate band, this provides married couples with the much publicised £1 million total exempt amount. It's therefore increasingly important in the appropriate states to ensure that any claim is successful. Although it isn't necessary for the first spouse to die to have owned a share of the family home, where it was owned jointly, the executors should be able to show that the first deceased had owned or part-owned the residence which is now passing to lineal descendants at the time of their death. It's therefore important to ensure that records are maintained to show an audit trail of the ownership of the house from joint names into the name of the survivor. Along with details of the property and what happened to it on first death, I've also set out the other information that's required for a successful claim. Again, I'm not going to talk about these here. The key, as I will keep mentioning, is good record keeping. So it's now back to Alison.
Thank you, Matt. So carrying on the theme of revenue claims after death and that information that 1 in 4 estates will be scrutinised, I want to cover briefly the very important and very valuable surplus income exemption. I'm sure many of you will be familiar with the bare bones of the exemption, setting out the statutory details on the slide there. A gift may be free of inheritance tax if it is out of income, if it formed part of the donor's usual or normal expenditure, and if it left the donor with sufficient income to maintain their usual lifestyle without having to draw on capital to do so. It sounds all very simple, and everyone or too many people unfortunately think it is very simple and make a limited effort or no effort at all to document what is necessary. But in practice and dealing with the revenue, we can assure you that these things are not as simple as they sound. There are very many myths and misunderstandings about how surplus income gifting works, and I've set out on the slide some common misunderstandings and assertions we hear from clients and some advisors. I'm sure the slide will change in a moment, and just so you can see a few comments in italics that we hear often from clients, I'm just going to read them out really. Any sums chargeable to income tax are income and can therefore be used for this exemption. Well, that is not the case. Certain funds which are charged to income tax are not income in the ordinary sense of the word. Just a couple of examples there. Withdrawals from investment bonds or the capital element of annuities. Many clients, for some reason, think that premium bond wins count as income, but they do not. Many clients and advisors assume that regular premium payments on a life policy are automatically exempt. They are not. The exemption is never an automatic right. It must be claimed, fully declared, and proven for each relevant tax year. We often hear, I can only go back 2 years. I can only use the last 2 years' income. Well, you may be able to go back further, but you must be extra certain that the income has retained its nature as income. Ideally, it's still in the bank account it first went to, and that the pattern of gifting is normal. Some clients will say, I must gift the same amounts to the same people each year. That is also not the case. The amounts and the recipients may vary, but they must be part of an overall normal approach to gifting, which, if challenged, can be proven. There are quite a few easy mistakes to make, which again I've set out on the slide. For example, failing to report a lifetime gift to a discretionary trust, which would otherwise, were it not for the surplus income exemption, be chargeable. For example, a gift of surplus income to a discretionary trust in excess of the available nil rate band. It's an easy mistake to make not to keep adequate records of annual income and expenditure. Without doing that, it can be unnecessarily time-consuming and expensive for the executors to investigate and prove the position retrospectively by having to trawl through check stubs and bank statements. It's an easy mistake not to undertake or document an annual review of income and gifting pattern. A very common mistake to make, or initial problem anyway, is where the high income earner or receiver, because the high income might be salary or it might be dividends, very often the case, particularly in married couples, that the high income individual will have their income paid or subsequently transferred to a joint bank account. This can fully or partially remove the ability to make surplus income gifts without some regularizing, if it is possible, before the gift. So let's just summarize with some top tips of how to maximize the surplus income gifting opportunity. We very strongly suggest, based on our practical experience, that for each tax year, the relevant part of the IHT form 403, which I'll show you in a moment, or a suitable similar spreadsheet is kept, along with a list of the dates and recipients of the gifts. As I'm sure you can see from and hear from Matt's comments and mine, record keeping is key. We recommend you undertake an annual review of surplus income, what's available, what was my gifting pattern, and what am I gifting this year, and what do I intend to gift in future years. It's often the case in a particular tax year that a client has a gap year or makes a lower amount of gifts in a particular year because, for example, there's less income that year or higher expenses, such as a building project. This isn't fatal to the normality of the exemption, but it should be documented to explain it. We really do want to ensure a clean audit trail of income paid into and out of the donor's sole bank account. As I mentioned earlier, beware joint bank accounts. We strongly recommend a letter of intent, or often as we call it, gifting memorandum, should be put in place. This very much helps evidence the donor's intent of normal giving. The minimum it should say is I intend to give between X and Y% of my annual surplus income to my family. In practice, it would say a great deal more than that. Claiming the exemption for any tax years where the gifts exceed the surplus income in that year is a complicated procedure. You might think we would say this, wouldn't we? But nonetheless, it's highly recommended that executors instruct specialist experienced advisors to present the details to HMRC in the best light with a view to securing the exemption. So the next slide will just shows you that relevant part of the form I mentioned, the IHT 403, which the executors have to complete upon the death of an individual where the estate is seeking to claim this exemption. This isn't optional, it's non-negotiable, so it is much easier if anyone who is gifting income on an annual basis keeps these records ready for the executors to use. So that ends our presentation, and we will turn to any questions. If we can work out the technology, I think now is the time, if you can bear it, that we will reveal ourselves and you can see us in person. And Wendy will lead us, I hope, through some questions. Just also to mention, before we get to that, apologies, the slides will be emailed to you after the presentation. And of course, after this questions page, there's a key contacts page. Please do feel free to contact any of us afterwards. Over to Wendy, thank you.
Thank you, Alison. I think most people should be able to see all three of us now, which is, well, maybe a good thing or not. So we have had quite a few questions coming in. Some people asking about the slides, which Alison has just answered, which is yes, they will be circulated. So you can all have those. And then a couple on witnessing of various documents. Now, on that point, the general rules are that witnesses should be over 18 and they should be as independent from the person signing as possible. So we typically recommend that spouses and family members should not be witnesses. Importantly, they also must not be a party to the document being signed. And there are different rules for different types of documents as well. So for example, if it is a will that is being signed, the witness must not be somebody who is intended to benefit under that will or the spouse or civil partner of that person. So that's one sort of special case for wills. And for lasting powers of attorney, there are also additional rules for witnessing, which is that the witnesses cannot be any of the attorneys, even if that's an attorney under a different lasting power of attorney, not the one that's being signed at that point. And a certificate provider is also required as part of the lasting power of attorney signing procedure. And that person must either be a professional or somebody who has known the donor of the power for over 2 years personally. So in short, there are specific rules for wills and lasting powers of attorney, but other than those specific rules, it must not be somebody who is a party to the deed, and it should be somebody who is over 18 and as independent as possible. And that would also be the case for somebody who's asked for deeds of variation in particular. So it should also be the case for those documents. Now, the next couple of questions were around the time of Matt's slides. So a question as to the definition of children, which under the Intestacy Rules includes biological and adopted children, but not stepchildren. And then there are slightly different rules that Matt covered for claims under the 1975 Act for those who are treated as children, that there are different conditions to be met there, even if they are not biological or adopted children, they might be treated as them. If we then move on to the next one, what happens if a beneficiary wanting to vary their inheritance under an estate does not have mental capacity? The short answer is that they can't then vary their entitlement because they don't have capacity to do so. and the only way that that could be done on their behalf is via a court application. It would have to be shown through the Court of Protection that it is in their best interests to vary their entitlement. And as you can imagine, that would depend on the facts of the case, because usually if somebody's giving something away, it might not be in their best interests, but there could be circumstances where it is. Now we appear to have lost Matt. No, there he is. So the next question was, I think, a more general one around HMRC investigations after death, and whether we could give any examples of cases that have been investigated and why they have been investigated. Again, Matt might have, or does have, more experience than me on this point, so may have a few examples, but one that I've seen is, for example, where a relief has been claimed for business property relief, and HMRC have just simply wanted to look into the facts of that case in more detail to see if they agree that the relief can apply. And it might also be, as the person who's asked the question has suggested, it might also be if the size of the estate is particularly big. Typically, the more inheritance tax is at stake, the more HMRC might be interested. But that's not to say that they don't investigate smaller estates. They still could do that. We've lost Matt again there. I don't know if Alison has any other examples, but it really does just vary, is the short answer.
Yes, quite. There is this, forgive me, I've forgotten the precise name of it, but a sort of high net worth, there's a special unit that investigates high net worth cases and small and family businesses as well. So they will often raise queries. And so, to some extent, it is rather just randomly computer generated in our understanding, because, as Matt says, 1 in 4 cases where inheritance tax is paid, they will investigate, and it's a bit of a, it's your turn. Matt may come on and have some other cunning plans, but for now we'll carry on.
So I think the next couple were actually from your shares, Alison, your slides, and that was, sorry, I've now lost them because lots more questions being added, which is great. So can we point in the right direction of a formatted method for recording gifts? I think that was answered with the example of the last page of the IHT 103 form. It shows an example of what the information needed on death would be. So that can be used and put into an Excel spreadsheet as suggested. And then there is a question about what counts as income. So somebody has suggested the proceeds of a share buyback. And my view is that they would not count as income because that would be sort of the disposal of a share.
I agree. Just to add that whoever has asked that is probably quite aware that it is often the case, in fact, invariably the case, that proceeds for a share buyback are chargeable to income tax. But as Wendy said, that doesn't make it income. It's still actually a proceed.
So I'm just seeing if there's any other questions on regular gifting before we go back to the claims section while we've lost Matt. Regular gifting section referred to income being declared. Do you mean annually declared? If so, how? Or just on the 403 eventually? That's a good question. Firstly, it's eventually on the IHT 403 when somebody dies. If you are claiming the exemption for any gifts in the 7 years before death, then you would definitely have to claim it. And also, if you are setting up a trust, as I think Alison mentioned, if the gift to trust would otherwise be chargeable but for the surplus income exemption applying, then it does need to be declared at that point of setting up that trust and claimed actively from HMRC at that stage. So those are the 2 cases where it must be actively claimed, but as we've been saying, it must also be recorded just for your own purposes, because you never know when that point of death is going to be and when the IHT 403 will be needed. So any more on lifetime gifting? Usual lifestyle, how would COVID-19 change this? Do you think this will change how it is assessed, less spending, so more room to gift? Is it a time when clients could be advised to take advantage and carry out more gifting? I think potentially yes. If they have more surplus income, then they could gift more of it. The key would be to show that it is that assessment or that individual's decision to gift that income has followed the same principles as their usual regular principles that they apply in other years as well. So if they have set out their intentions previously, for example, to say, yes, I'd like to give 100% of my surplus or 50% of my surplus, and their surplus is bigger this year than in others, then yes, that could apply and that could follow. So I'm just going to go back up in the questions because we've focused on surplus income for a little while now. Regarding claims on an estate, please expand on who are cohabitees and financial dependents. Can a non-married cohabiting partner claim? Can an adult child claim? And I think the point here is that bringing a claim, yes, they can bring a claim. It's as to whether they'll be successful in that claim that we really need to be careful about advising our clients on, because anybody could make themselves a nuisance by bringing a claim and saying or arguing that they are financially dependent. But the points that they would need to prove in order to be successful in that claim would be precisely how they were being maintained. And that would be if they were an unmarried cohabitee or an adult child who wasn't living with the person who had died, provided that they could show that financial support had been provided by the deceased. So question on gifting shares. Can shareholdings be gifted by a simple letter, no formal deed or witness required? Technically, yes. Items can be, the beneficial interest in an asset can be given, but for that to be formally recorded, it is always better for it to be by deed. And furthermore, for the legal title to transfer, you would usually need a stock transfer form or a share transfer form to be lodged with the company as well. So a decision would need to be made about whether you are gifting just the beneficial interest and continuing to hold the share on bare trust, or whether you are also intending to transfer the legal title in the share. So then we had more on surplus income, which I hope we have covered. Lasting power of attorney, trouble with witnesses. Yes, it is. We are also finding it very difficult to find witnesses, particularly for lasting powers of attorney, because there are so many people involved, and for each person signing, that rules them out from also being an attorney, and it adds to the high level of independence that is needed. But yes, as you said, different households can often be the answer here, whether that's neighbours or for people who are able to leave the house to go to work if they are key workers, that might be colleagues, subject of course to the social distancing guidelines of remaining at a 2-metre distance even when witnessing the documents. So I'm just checking up on time. We're sort of getting to the end of the hour, so some of these questions might need to be dealt with afterwards. I presume that the HMRC inquiry might well focus on taxation of the income subject to inheritance tax as well. I think that's just to say that, and that's a question which is to say that whether HMRC investigate cases on death might also depend on, for example, if they are claiming the surplus income exemption. So yes, exactly. If the gift is or would otherwise be subject to inheritance tax, i.e. on death or on a lifetime transfer to trust, then yes, that is when the exemption would need to be claimed and when there is a risk of HMRC investigating it before they approve it. ISA income be included in the regular gifting of income, even if it physically remains in the ISA wrapper. Now, I think that would depend on the product as to whether it is possible to actually make the gift out of the ISA wrapper. If it is dividends or interest received on an ISA, then that would count as income for the purposes of the exemption, but you would need to be able to make the gift as well. Now, one question that's on a slightly different subject. You mentioned that FIX may be attacked by HMRC. Can you share your thoughts on what you think may be attacked? Now, I think this was just as Alison had said, it's a relatively new task force that perhaps because they have been productized in recent years, they are just looking into them more as to whether they are, what purposes they've been set up for. And unfortunately, as it's quite a new task force, we haven't seen many examples of that, I'm afraid, but it is just one to look out for. Now, are there any more slides? Yes, some very kind comments. Back on claims, is the key that financial dependents were receiving some sort of maintenance before death? Broadly speaking, yes, that would be the key to the claim being successful. Now, I think we are running out of time, so hopefully I've not missed any questions there. But if we have, or if you have any others that occur to you once the webinar has over, then of course, please feel free to contact us, and we'll do our best to answer them and to help out with any cases you may have.
Absolutely. Well done, Wendy, for going through all those questions. Thank you very much. Thank you very much indeed for all the attendees. We look forward to seeing you again soon, and until we can see you, hearing from you, calls and emails. Please, everyone, keep well, stay safe, and we hope to webinar again with you soon. Best wishes. Bye-bye.
Thank you very much.
Bye.